Bill, a 15-year-old youth, is currently placed in a RTF because of a delinquency adjudication. At his last hearing, the RTF told the judge that Bill would be discharged in a month. Bill has an open child welfare case as he has been involved in child welfare since age 7. Bill's child welfare caseworker convenes a multi-agency team meaning to develop a reentry transition plan for Bill for his return to the community. In attendance at the meeting, the child welfare caseworker, a representative from RTF, a teacher, and a school counselor from the local high school that Bill was attending before his placement, an outpatient mental health counselor who treated Bill previously, and a juvenile probation officer. Everyone is confused about whether they're allowed to talk to one another and what information they can share.
Thank you so much. So a common scenario for people who are working, particularly with kids who are involved in child welfare or juvenile justice, this concept of having interdisciplinary teamings for these children is a best practice that we want to promote. We want people to come together and develop plans together so that there aren't we aren't working at cross purposes, duplicating or have conflicting plans, and that everyone's on the same page in implementing the plan. A great concept, but it does get confusing when you have so many professionals who are governed by so many different laws. So in this case, going back to our key questions, everyone at the table has information that the other one wants. And right, everyone wants the other one's information. So it's kind of hard to figure out what, you have to really parse it down to basically who works for who, what kind of agency, to figure out what laws pertain. The general information that people want is the information from the residential treatment facility or residential treatment center about the child's progress in treatment, what the prognosis is. I would say probably the recommended discharge plan, what kind of discharge plan for the community, the facilities putting together. And then they'd want to know from the outpatient mental health treatment provider what kind of services could be provided to Bill once he returns. Same thing with school, the treatment center, presumably, but we don't know for sure, we'd have to ask, but Bill is attending an on-grounds school at the treatment center. They have education records. We need to know, the team would need to know how he's progressed in school, and would need to know that information to figure out where to place him in the new school in the community. We don't know this from the scenario, but there's a good chance that Bill has an IEP if he's a treatment center. So both FERPA and IDEIA would govern any education records that were generated in the school at the treatment center, as well as his records in the local high school he was attending. So FERPA and IDEIA would govern the release by those entities of his education records. HIPAA would govern the release of any of the treatment records that the treatment center has, and govern the ability of the people in that teaming to get access. So let's break it down for a moment. Let's look at the education records. We know from the Uninterrupted Scholars Act, the amendment to FERPA, that child welfare agency workers who have access to the child's case plan and work for an agency that's legally responsible for the care and protection of a youth as that's defined under state law, can have access to the child's education records. What USA also says is that the child welfare agency worker in turn can share that information with anyone else that the agency recognizes as needing that information in order to get education services for the youth. So in this scenario, the children and youth caseworker is clearly able to get information both from the treatment center school and the local high school that Bill will be or was attending under this exception. The exception would also allow, if that agency had a policy that allowed the agency caseworker to give information to the other people at the table because they were needed to implement that education plan, USA would also permit that. absent that kind of agency policy, then you'd have to again get the signed authorization of Bill's parent, who is conspicuously missing from this scenario, but you'd have to get authorization from Bill's parent or whoever has been appointed as his educational decision maker or surrogate parent under IDEIA to sign an authorization to allow those other folks to get the school records. Was there a hand up here? Yes, there was.
I just need clarification. I thought that the Uninterrupted Scholars Act only applied to child welfare cases, not juvenile justice cases.
It does.
In this scenario, the child was placed out of home because of a delinquency case, not the child welfare case.
Ah, yes.
That's my read of the scenario. So would the Uninterrupted Scholars Act apply because he's actually out of home because of juvenile justice, not child welfare?
That's an excellent point. That is a really excellent point. I hadn't thought about it that way. He's been in the system since 7. You know, that's an excellent point. It makes me want to rewrite this scenario to close that little loophole. But you make a great point there. Wait, let me think about this a moment. I'm sorry, you want to respond to that? Oh, go ahead then. I'm sorry. I mean, what I was going to say was, you're right. It's not clear that he's under, well, it says that he, remember, the USA says, and literally I was looking at the language while we were on the break because I wanted to make sure I got it down. It says if you are legally responsible for the care and protection of the child. So to the, you know, in my jurisdiction, Pennsylvania, we keep open child welfare cases when people go into juvenile justice, and we are very adamant about making sure that everyone involved understands that the child welfare agency is still legally responsible for the child so that they don't close the case on. So I guess in this scenario, even though he was placed by the juvenile justice system, I would still think that he is under the child welfare agency is still legally responsible for his care and protection, hence why they convened the interagency meeting. But you're right, it's fuzzy here.
Colorado, in that scenario, the Department of Human Services pays for the placement.
Right.
And supervises the placement. There's
Right.
actually a treatment plan in place. So from that perspective, I could see that the USA would apply.
Right. But the USA would definitely not. I mean, I know when I say it doesn't apply to the juvenile justice system, what I meant to say is that it wouldn't allow the juvenile probation officer in this case, even though arguably he is also legally responsible for the care and protection of this youth under whatever state law you may have that governs juvenile justice placements, he would not be able to get this information directly from the school. And I'm sorry, you did have a comment or follow-up for this.
I was going to say exactly what you said.
Okay. Great. Perfect. Thank you. No, but that's a great point. I'm like, maybe I'm going to have to fiddle with this. I didn't intend, a lot of times I do intend to put like hidden little loopholes and stuff in here for people to catch, but that certainly wasn't one that I wanted to. Other questions or comments on this one in particular? Okay, so that was about the school records. We still have treatment records from the center, and those records are clearly going to be governed by HIPAA. And the same things that we talked about earlier, basically, if the parent was the one who had to consent to the health care at the treatment center, the parent would have to sign an authorization to allow the treatment center to release all this information to the team, any member of that team. Alternatively, the court could order the treatment center to release that information to the team under HIPAA, which is always a good practice as well. So those are sort of the two options there. But unlike the USA for FERPA, there is no HIPAA exception for all these people who are working to put together this plan. Okay, oh yes, please. And then this young woman here, go right ahead.
So, does the release have to specify that it's the RTC, it's only the most recent stay at this RTC? They can't talk about the stay back when he was 11? Do you see what I'm saying?
I'm not sure what your question is.
Okay, if we're getting the correct release sign,
Right.
does it have to specify the time frame of this placement? Because let's say maybe the kid had a placement 7 years ago, then
At the same
went back to
RT.
his, yes.
I mean, the going back to the HIPAA, what's in a HIPAA authorization. So it does have to have a specific description of the protected health information to be released. And so you're supposed to give as much specificity as what you want. It doesn't specifically require that you put in date ranges for the treatment that you're seeking. So I think this comes down to one of those areas where it's up to the institution's practice whether or not they want you to give them specific date ranges for the records. But if you just wrote down all these kids' records, like I represent kids and I send signed authorizations to get all of my kids' records. If I'm signed to represent a kid in a dependency proceeding or a delinquency proceeding, I expect everything from day one to come to me. Normally, no one says to me about what dates. I think unless you carve out dates, they're supposed to give you all the information they have. Is that answering your question? Okay. You had a comment? Yes,
I actually have two questions.
please.
So my first question is if there were psychotherapy notes in that file and for some reason someone wanted access to those, and there was no authorization that was signed, would a court order be sufficient for the release of those psychotherapy notes under HIPAA?
No. That's a really great question, okay? And that sort of goes to one of the, we talked about exceptions to the signed consent rule. And one of them is subpoenas and court orders. But HIPAA very specifically says that psychotherapy notes can never be disclosed pursuant to a court order. You need the patient's consent for that. Because things, there's a something similar in the drug and alcohol rules. The things that we say to our therapists or that we actually say to people who are caring for us are probably the most protected things under the law. So it makes sense that you really can't get a court order to get someone to turn over notes about what a patient said in therapy. That you have to get the patient's consent. So that's a great question.